Good morning. Please be seated. Welcome to the Utah Court of Appeals. We're going to hear two cases today through argument, and the first one is In Re P.J.R., case number 20220264. Make sure I've got the right file. All right, counsel, can you make appearances, please?
Yes, Emily Adams for the appellate mother.
Good morning, Ms. Adams.
Martha Pierce, attorney guardian ad litem for the minor child.
Morning, Ms. Pierce.
And John Peterson, Assistant Attorney General.
Good morning, Mr. Peterson. It's nice to see you all in person. It seems like it's been a lot of video screens over the last couple of years, but it's good to have you all here today. I don't know that I need to say anything preliminarily. I think we can just get going. Looks like 12 minutes on the clock, so that means 3 minutes for rebuttal. Has that been handled?
Yes, Your Honor.
Okay, Ms. Adams, we look forward to hearing your argument.
Thank you. Emily Adams for the appellate mother. Your Honors, mother has raised two broad arguments in her opening brief. First involves whether the district court made the appropriate findings about reasonable efforts and whether the juvenile court should have granted a motion for judgment as a matter of law. Let's first get out of the way what's not at issue in this case. Mother argued in her opening brief that juvenile courts in this context are required to make a finding of reasonable efforts by clear and convincing evidence. The state and the GAL have not argued that that is contrary to the law. Mother also argued that the juvenile court here did not make an explicit finding of reasonable efforts by clear and convincing evidence. The state and the GAL also don't take any issue with that. And mother also argued that the juvenile court had the authority under the rules to grant or to rule on a motion for judgment as a matter of law, and the state and the GAL also don't argue that that's not the case. So the question becomes here, what is this court supposed to do with this termination order that doesn't have an explicit finding of reasonable efforts by clear and convincing evidence? The state and the GAL argue that this court can affirm that order because either there's a clerical error, the court meant to make this finding by clear and convincing evidence, or there's an implicit finding. But both of those arguments are not persuasive whatsoever. A clerical error occurs when the court has issued a judgment over the bench and the clerk types it down and makes a mistake in the typing. But here it's very clear that the judge never issued any type of ruling from the bench. There was a 2-day termination trial, well actually kind of a 3-day termination trial, and at the end the court said, well, I'm going to take this under advisement, and it issued a ruling 4, 5, 6 months later. And so the ruling that we have, the termination order, is the court rendering the judgment. It's not a clerical error. As for, yes,
Can I ask you a question, Ms. Adams? Tell me how your client gets over the stipulation that was entered into on November 19th, 2020, that she had failed to participate in, comply with, in whole or in part, or to meet the goals of the ordered service plan. And then she, at least if she didn't specifically request that the court terminate reunification services, she at least acquiesced to the termination of those services. Doesn't that, in a way, that stipulation indicate that she basically is acquiescing to the fact that DCFS has provided reasonable efforts? I mean, she's the one acknowledging that she didn't comply with the service plan. How can DCFS make her comply with the service plan?
So I have two parts to the answer, Your Honor. The first one is that she made it very clear, counsel for mother made it very clear that that was a stipulation that was just for purposes of the permanency hearing. The parties had a very extensive discussion before the permanency hearing occurred. They negotiated for several hours and then ended up with this stipulation. So there was a lot of factors at play where mother said, you know what, for permanency purposes, it doesn't make sense for me to challenge reasonable efforts, just for permanency purposes. And also, the reasonable efforts decision is actually a two-pronged finding. First, the court has to find that DCFS, or the state, provided reasonable efforts, and then also that the parents weren't able to comply with those reasonable efforts. So although mother might have said, you know what, I'm going to stipulate for purposes of this permanency hearing that I didn't comply with the child and family plan, that still doesn't tell us anything at all about whether DCFS provided reasonable efforts. And I think when you look at the 2-day trial here, there's a lot of evidence about how DCFS, at least the caseworker, and at points.
Are you, as you stand here today, are you acknowledging or conceding that there was such a stipulation? It sounded like trial counsel was not prepared to acknowledge that at trial.
Well, the stipulation, I think, well, I mean, we've got the stipulation in the I think it's what, the September or whatever, the permanency hearing order.
November 2020.
Permanency hearing order. And I think the way that I read trial counsel's discussion at trial is that was a stipulation that was just for permanency. And Mother didn't request that her services be terminated. She just said that she wouldn't argue against it. And so they had gone through this extensive negotiation and had decided that for purposes of this case, it didn't make sense to challenge.
As I understand what happened there was some negotiations, and the parties appeared back in front of the court and put their stipulation on the record. We don't have in our record that got sent up to us an official transcript of that proceeding. It's unclear, I guess, whether the reasonable efforts part of the stipulation was part of what got put on the record, but what's not in dispute is that the state prepared a proposed order following the hearing about what had been said on the record, and trial counsel didn't object to the state's characterization of that. That included a reasonable effort stipulation, and that got entered as the order of the court. Do I have that right?
You have that right, Your Honor, but the problem is that still that reasonable effort stipulation didn't include a finding by clear and convincing evidence. And so even if we have this reasonable effort stipulation, we still haven't met the burden of proof here.
Okay, well, let me go back to the burden of proof issue, which is where you started. So in the court's order, the court does, in paragraph 3, when the court is discussing grounds, the court does talk about that the standard is clear and convincing evidence. Then 2 paragraphs later in paragraph 5, when the court gets to reasonable efforts, the court doesn't repeat clear and convincing evidence. It probably should have. It would have been clear. The court didn't repeat it. But the court doesn't ever say it's applying a different standard. And so I guess, so let me preface that with another question. Let me make sure I understand how this all went down too factually. As I understand it, there was a trial in November or so of 2021. Then the court set a date to announce an oral ruling on February 8th of 2022, and then did announce an oral ruling, and at the conclusion of that oral ruling asked the state to prepare what turned out to be this order. That order was circulated on the 14th, and then there was a limited objection made by trial counsel to the form of the order. But that limited objection didn't include anything having to do with the burden of proof or the standard of proof. In other words, trial counsel didn't say, hey, you should go back and add that.
Yeah, trial counsel just objected to a characterization of the evidence.
So that was trial counsel's opportunity to object to this issue if trial counsel thought that there was a problem. The order then gets entered, and that's what we have here. So those are the facts, right? Do I have that? Do I have those right?
Right.
Okay, so let me read you a paragraph from a case from our court a couple of years ago. It's Gerwe versus Gerwe, 2018 UTAP 75. That's a divorce case. Justice Hagan's writing the opinion for the court. Although the district court did not expressly state, this is paragraph 13, that wife presented clear and convincing evidence of fraudulent inducement, it never suggested that a lower standard of proof applied. A reviewing court will not presume from a silent record that the court applied an incorrect legal standard, but must presume the regularity and validity of the court's proceeding and that it applied the correct legal standard in the absence of evidence to the contrary. Cite, because nothing in the record suggests that the court applied something less than the clear and convincing standard, husband cannot establish error. I don't know if you're familiar with that case. I know I'm springing this on you, but I'd really like your thoughts as to why that same principle that we announced in Gerwe in the divorce context wouldn't apply here.
Because it's not clear from this order that the district court, it's clear from this order that the district court didn't apply the appropriate standard of proof. So Your Honor pointed to paragraph 3 of the termination order.
Right.
And what's interesting is that's under the subheading that's grounds for termination. And the court specifically says the DCFS has proven by clear and convincing evidence the grounds for termination. So its standard of proof as cabins strictly to grounds. And then it moves on to reasonable efforts, which is a separate subheading. And the court never in its reasonable efforts analysis talks about the burden of proof. And so, and then when we get to, the other like best interest and things, the court doesn't address the burden of proof because the parties have stipulated to best interest. But here, the court at the very end of the termination trial said over the stand that it was very conflicted about the evidence. That it said at one point I was going one way and then I heard more evidence and I was going another way. It was very, very conflicted about how it should resolve this issue. And so I think that as we argue in our opening brief that the burden of proof would have mattered here. And it's just not clear from this record whatsoever that the court didn't ever say that the standard was clear and convincing evidence. And in fact, it cabined its clear and convincing evidence burden just to grounds and not to anything else.
And it's not significant in your view that the court didn't say it was applying a different standard 2 paragraphs later. In other words, it didn't say, for reasonable efforts, I'm now going to downshift to a preponderance standard.
No, because because in civil cases, which these cases are, the default is preponderance. And so when we default, whenever we look at evidence in a civil case, the default is preponderance. So the way I read this order is that the default was preponderance. In termination proceedings, the default seems to be clear and convincing, no? Well, it should be. It is. But in this case, the court didn't say. It was very specific in its grounds analysis that it was clear and convincing, and then said absolutely nothing else, and didn't hold the state to its higher burden, as we argue throughout our brief. That I think the evidence was extremely conflicted here, and had this court held the state to a standard of clear and convincing evidence, there's a reasonable likelihood that the court would have come out on a different side. Unless the court
can we at least infer there's the additional, or the paragraph that begins says additionally throughout the court case, the court has consistently found reasonable efforts. If we review any of those prior findings and the court did say clear and convincing, does that matter?
So the only time we have even a mention of clear and convincing in any of those prior orders is the one in September of 2020, which is September of 2020 is when they do their adjudication disposition. And the court reviews the state's the state's child and family plan and says, this is clear and convincing evidence of reasonable efforts. But reunification hadn't even started yet. That was the order that started reunification. So none of those orders, from what I'm aware of, actually give the burden of proof, and they never say, and I can double check during the state's argument, but they never say that the court was finding by clear and convincing evidence that DCFS had engaged in reasonable efforts. And I know we didn't talk about the failure of parental adjustment, but that's kind of the state and the GAL say, hey, the court made a finding by clear and convincing evidence of failure of parental adjustment, and implicit in that is a finding of reasonable efforts. And the thing is, the court never mentions reasonable efforts in that paragraph where it talks about failure of parental adjustment. It never cites the definition for failure of parental adjustment. It cites a different statute which talks about evidence of failure of parental adjustment, and that's all parent-based. It's not state-focused. And that's the big difference here. Reasonable efforts is focused on what does the state do. It's not focused on what does the parent do.
I know your time's up, but I'd like to get your thoughts on the judgment as a matter of law issue. Mm-hmm. This trial was a little different, I guess. Maybe this is how reasonable efforts trials go. I don't know. We haven't seen too many of these percolate up to us. But where the state didn't actually call anybody, the state first asked for the court to take judicial notice of the entire court file, and there was an objection to that, and eventually that was narrowed down to judicial notice of 18 or 20 different orders and plans and things that were then officially admitted as evidence. And then the state rests. And at that point, there was a motion for directed verdict or a motion for judgment as a matter of law made. And I'd like your thoughts on at that point, is the state sort of over its burden to demonstrate reasonable efforts just based off of the documentary evidence?
I think that if you had a case where you had an order from the juvenile court that said that there was clear and convincing evidence that the state had made reasonable efforts, and that was based on some kind of evidentiary hearing, I think very likely yes. The state would have reached its burden on that point, or could have. enough where there was at least an issue of fact where the court
Yeah.
needed to decide. But here, the state didn't even create an issue of fact because all the orders that it presented to the court were orders where there wasn't any finding by clear and convincing evidence that the state had made reasonable efforts. And so in that case, the state hasn't met its burden because all the evidence it's produced has been preponderance.
Some of those
evidence.
orders do say the reasonable efforts. One of them uses clear and convincing language, and
But-
one of them is a stipulation.
So yeah, so the first one, that's the September 2020, where reunification has just started. It's the day, that's the order that starts reunification. It says, well, if the DCFS does this stuff, that'll be, that's clear and convincing evidence of reasonable efforts. But from everything there on out, we don't have, oftentimes the phrase reasonable efforts is not used. Oftentimes it's finalizing the permanency goals. And remember, the permanency goals for these children were concurrent. It was adoption and it was reunification. And so there wasn't anything in all of these orders that said, hey, this is what DCFS has been required to do under the Child and Family Plan, and there's clear and convincing evidence that they are making reasonable efforts towards that.
Do you see a distinction between evidence sufficient to get the state to a prima facie point where they've carried their burden, and then that can be rebutted on defense?
Right.
Between that on the one hand and these orders acting as sort of conclusive proof of reasonable efforts. I mean, there's a difference between those things. And the court here didn't treat these orders as conclusive evidence of reasonable efforts. It listened to trial counsel's defense and then made a finding in its order about that. Do you see what the distinction I'm talking about? Does
Yes.
that resonate in this context?
No, it doesn't, because here, no matter how much preponderance you have, it doesn't reach clear and convincing. And so there's a distinct difference between those two standards of proof. And when the only evidence that you're admitting at trial in your case in chief are orders that are based on preponderance, I don't care how much preponderance you have, it's 51%. Clear and convincing evidence is higher than that. And so at that point, you haven't met your burden. You haven't met your higher burden of clear and convincing evidence. You're right that I think the court, in my view, should have granted the defense counsel's motion for judgment as a matter of law. But I appreciated that the court declined the state's invitation to rely solely on those orders and then,
They just call the case over, yeah, right.
Right, and the court was very concerned with the state's approach in this case.
Yeah, the court seemed to treat them as some evidence of reasonable efforts, but not conclusive evidence of reasonable efforts. And I guess I wonder, so you think that approach is wrong?
I think that approach is wrong. I don't think they've even met a prima facie case because none of those orders were based on evidentiary hearings. And none of them said, except for that first September 2021, none of them said that the state had reached its burden, or September 2019, I apologize, had reached its burden by clear and convincing evidence. That language didn't show up. Yes, Judge.
But once again, I know you're arguing that it was limited only to the permanency hearing, which occurred in November 2020. Mom does stipulate that DCFS or other agencies continue to make reasonable efforts to assist the family finalize the service plan and its permanency goals. November 2020, trial occurs, what?
2021.
2021, and Mom has
later.
already agreed to terminate reunification services in that time. Isn't that sort of a final determination that the court or the DCFS has provided reunification services, reasonable efforts?
So the language that I latch onto is in that November 2020 permanency order is DCFS or other agencies continue to make reasonable efforts to assist the family in finalizing the service plan and its permanency goals. To me, that's not a clear stipulation that reasonable efforts occurred, because finalizing a service plan means that the service plan is still in flux. Like they're changing it, that's not actually engaging in the service plan, it's merely finalizing it. And like I said before, the permanency goals were adoption and reunification. So it's not clear that, that the finding here, the stipulation here isn't clear that Mother was stipulating to, they've done everything that they need to do.
Let me shift your focus to the first paragraph of that stipulation. The main argument being made by trial counsel against a reasonable efforts finding had to do with animosity or friction between Mom and the caseworker, specifically about family therapy, about the caseworker getting in the way of family therapy. And this stipulation in paragraph 1 seems to sort of do away with that. Parties agree that the communication regarding family therapy that resulted in family therapy being stopped should not be a factor in the court's determination of reasonable efforts. What do you make of that?
So you need to go to Record 1312, and that's during the trial, and the parties actually discuss this finding, and the state makes it clear that goes towards my notes say weird finding in the permanency order about, and it's CUCC, which was the name of the therapy place, not playing into reasonable efforts. This had to do with family therapy with the younger girls. It didn't have to do with Paul. So it's page 1312 of the record.
Okay.
So, unless this court has any other questions, yes, that this court reverse. Thank you.
Okay, thank you.
May it please the court, Martha Pierce, attorney guardian ad litem for the minor children. This court is correct that the Gorley versus Gorley, that wasn't plowing new ground. The presumption of regularity has always been there. Counsel wants us to presume that the trial court got it wrong when it omitted to say what the standard was. But on appeal, we presume the trial court got it right. So that's the burden at the appellate level. And the presumption of regularity, that's just a bedrock principle of appellate law. I think it was also you, Judge Harris, talked about mother's compliance with the service plan. And the Supreme Court made a similar finding. In Ray KF, 2009, Utah 4, paragraph 53, it talks about the standard for finding reasonable efforts, but it said ultimately it's the parent's responsibility to comply with the service plan. And counsel at the trial level didn't seem to be quibbling with the eight jobs of the state. It had a new theory. It was saying, I really want to talk about the animosity. That was their theory about why there wasn't reasonable efforts. And counsel seemed to say that counsel had a very skewed view of what the caseworker's job was. Counsel seemed to think that if you're not always in my corner at every minute, then it's not reasonable efforts. But the caseworker's job is much broader than that. If you look at 406, 80-3-406, there's about 4 or 5 different places in that provision where it says the court at any time can terminate reunification services and change the goal. Because things change, things are flux. So the caseworker had a duty to enforce federal law. The caseworker had a duty to see how things were going. When the new charges came up, the caseworker had a duty to inform people about that because those were felonies. And even though Mother's brief said, well, those charges were dismissed, the site is citing to Mother's testimony. The charges weren't dismissed. They're still outstanding. There's 13 of those charges in Manti, 9 of which are felonies. They all go to child abuse. So
when you say they're still outstanding, they were at the time of trial? Or
they were at the time of trial. Mother said they were dismissed. That's what they're citing to, but they weren't. That's just Mother's testimony. They're still outstanding today. There's 9 of them. And that was crucial information for therapy because that was the children's lived reality. And if the little boy was hesitant to go to therapy with his mother, all we have to think about was what happened the last time the little boy was in therapy with his mother. That's where she strangled him in a space that was supposed to be safe. That's what she did in front of other people. If that's what she does in front of other people, what does she do behind closed doors? Of course she's going to be reluctant to do that. And the caseworker's client wasn't only mother, the caseworker's client was also the child. So, and the caseworker wasn't in a position to make a therapeutic decision about when everyone is ready for therapy. And for instance, Mother's therapist testified that, oh yeah, she's taken accountability. But you look at, well, how did she take accountability? Well, she said that her big fault was choosing the wrong men. She never took responsibility for the abuse. And
just factually, let me make sure I understand. Did family therapy ever occur between Mother and Paul?
no, it
So
did
when
not.
the court talks about the delay in starting family therapy, it was a delay that lasted the entire reunification period.
Well, when I said delay, it was never recommended. Normally what happens is the child's therapist will make a recommendation that now we're ready to have this happen. But you never ask a victim to sit down with their abuser and go to therapy when the abuser hasn't admitted to any of the abuse. So it was never recommended by the child's therapist, even though mother's therapist kept pushing for her to do that. And then the court gave us oral rulings, but we have no idea what happened at the oral ruling because there's no transcript of that. So
my recitation of the facts that how that happened, there was an oral ruling, and then the state put the form of order. You think I've got that right?
You got that right, but we don't have the transcript of that oral ruling. We don't have that. But now that we're talking about that, the mischief that the invited error doctrine is supposed to prevent is evident in this case because the court gave some proposed findings. Mother had a quibble with one line about advice and about a stipulation, but she said nothing about the omitted burden of proof. She said nothing about the failure of parental adjustment. So this almost looks like she's pocketing those two claims for use on appeal later on, and that's precisely the mischief that the invited error doctrine is supposed to prevent. So it's not fair to any of the parties for her to bring it up now when the only likely recourse is to give it back to the juvenile court, and the juvenile court is going to say, oh yeah, clear and convincing evidence. Of course, I knew that. I just didn't put it in there a second time, and nobody flagged it for me. But I'm going to put it in there.
What do you make of the way the trial happened on the state side? I know you're the guardian. This is the state over here, but do you have thoughts on whether these documents that were admitted, and the 18 or 20 of them, whether those are sufficient to constitute prima facie evidence of the state's burden?
It definitely constitutes prima facie evidence because and the judge kept. You could see the judge was getting sore about that. The judge and the parties should get to rely on all those numerous interim findings of reasonable efforts. There's a reason you go to court all the time and talk about reasonable efforts because there's not supposed to be any surprises. And if there is an issue with reasonable efforts, you're supposed to be able to fix it at that moment, at the time where it's going to benefit the child, at the time it's going to benefit the mother. You don't keep it in your back pocket and bring it up at the time of trial or at the time of appeal.
What did the court mean when the court said the mother has consistently objected to the finding of reasonable efforts? It's in the court's order. You know what the
That's in the court's order, and the court is referring to the mother's theory that even though the state may have complied with what's in the plan, and that's in 80-3-4612, the court announces what everyone's duties are so that later on when there's a finding to be made about reasonable efforts, everyone is made aware of what the roadmap is, the yardstick is. So the court was referring to mother's theory that, well, because the caseworker wasn't always in my corner, then we can't possibly make a finding of reasonable efforts.
But are you aware of any evidence during the course of the reunification period where there was an actual objection to the finding of reasonable efforts made in any of these interim orders?
It was the opposite. In fact, the judge took
right, that's where I'm confused, is the court said mother has consistently objected, but then you go back and look at the hearings that happened during the reunification period, and I'm having a hard time finding those objections.
The most you can get is mother's complaining that the caseworker isn't in her corner, because the judge will often say, well, Mr. Prue, would you add anything to the plan? No, I won't. Do you have any objections? No, I won't. Will you sign it in open court? Yes, I will.
Yeah, we have a transcript of the 6-month review hearing, and the court asks trial counsel directly, is there anything specifically that DCFS should be doing that they're not? And he said, I don't have anything specific for you at this time. We don't have the transcript of any of the other ones. That's the only one we have. And so maybe this is a better question for Ms. Adams.
And we have to speculate because we don't have those transcripts. And my best guess is that mother was complaining about her disagreement with the caseworker, which is going to happen. And I think the judge handled that really well and very nuanced. Unless there's any other questions, I'll thank the court for its time.
Thank you, Ms. Pierce. Mr. Peterson?
May it please the court, John Peterson on behalf of the state of Utah. To kind of start where Ms. Pierce led off with you, and I believe I think the court had a sense that there was this kind of simmering dissatisfaction. I mean, throughout the case, you had the one exchange was at around record 313 to 315, where Mr. Pruitt trial counsel said something on the fact of it is what it is, and the judge is like, no, and he said, I want to get behind this. Is there a problem? And he said, no, we don't want anything. And that was really throughout the case, there was these general kind of grumblings of dissatisfaction that, you know, the mother felt somehow she was being wronged, but really what was happening is that mother was not complying and not really doing her part, and it's much easier to lash out and blame somebody else. I mean, and I'm not saying that there wasn't some conflict between the caseworker and the mother. They did seem to, you know, butt heads a bit at times, but, you know, I think the juvenile court very thoroughly, again, you know, I think out of exercise caution addressed this conflict in the court's final order. And I mean, I think given the course of these proceedings and all the concessions to reasonable effort throughout the case, I don't think the court was required to do that, but I think the court was very thorough and acknowledged that this has been an undercurrent, you know, throughout the case. I think that really what it was. It wasn't a specific, there was no, as you noted, Judge Harris, there's never been throughout the case, no objection, like you're not providing reasonable efforts. I want to do, every time the court asked, what can we do? There was no response. And then there was, at the permanency hearing again, like we want to have an evidentiary hearing and error laundry and figure out what's going on here. No, we're going to stipulate that there's been reasonable efforts.
Right. That's the dissonance I'm seeing is there's this statement by the court about mother has consistently objected, but then we have the stipulation at the end of the permanency hearing, and we have really no evidence that I could find that there was an official objection at any point during the reunification period.
Yeah, I think, as you noted, you know, we don't have transcripts of all the various rehearings, but you know, I think there's enough going on that the court sensed that there's these grumblings. They didn't rise to the level of actual objections or actual requests for anything, but there were just general grumblings throughout the case, and the court decided, you know, I'm going to address this because clearly, I'm aware that you feel this way, but.
And does it make sense to you that the court was treating these interim orders as sort of prima facie evidence but not conclusive evidence?
I think it does. Yeah, I mean, these proceedings are a little bit unique, and they have such a long degree of review. But I think that, and the court wants to make sure. You know, there is, as I said in my brief, there is, you know, law of the case. There's decisions made during the case, and there's. I mean, we don't want to, like, it's not like every hearing is a new day and everything, all the water passed on the bridge is now gone and different. I mean, these are ongoing proceedings, and the court is, you know, taking advantage of its opportunity to review the case very frequently to make findings, and some of them even by the clear and convincing burden of proof. And so, I mean, and then especially then you get up and you have an actual stipulation again. And, you know, I mean, and counsel again tries to walk it back, saying, well, it wasn't really a stipulation, it was kind of a stipulation this, without this. But I mean, but it was a stipulation that reasonable efforts were being made, and which followed up on a whole case of reasonable efforts being made and no objections whatsoever. I mean, it seems like, I mean, this is almost the poster child, you know, for invited error and, you know, failure to an unpreserved error. You get to the trial and it's like, well, we're going to have a trial on reasonable efforts. It's like, well, on what? You know, throughout the case, you conceded, and really the only thing, again, is this the family therapy issue, which, you know, was laid to rest by the stipulation. I mean, they pointed to the record where Mr. Proulx, again, you know, tried to walk that back and say, well, it really wasn't that, it was something else. But like, this is the order entered by the court. You know, and they didn't object to the order entered by the court and say, well, that order isn't accurate. Like, well, it wasn't accurate, maybe you should have objected to it, because it seems accurate. And, you know, there's an official transcript of their discussion about entering that too, which seems to support the court's order. I mean, and the difference about whether we agree to terminate service or
well,
agree
it's
to
funny. There was a transcript of that hearing made. It's in the actual care file that gets imported up, and we can look at that. Yeah. But somehow that didn't get put in the record, the official record on appeal. And if you go look at that transcript, what got said at the hearing didn't include anything about reasonable efforts, but then it shows up in the order. So was that something they agreed to at the negotiation, but just didn't say on the record at the hearing, or I don't know, right? I mean, this.
Yeah, the law, time immemorial has been, you know, the final, the memorialized order is the order. I mean, and that is the final say. And if you don't like the order, then you better object to that order, because that's what you're stuck with.
Seems like at least some evidence that there was reasonable efforts, and you can then try to explain that away in defense, right? I mean, is that the way you see it?
Yes. You know, I think the court gave them the opportunity to present their evidence, and after hearing, you know, once again, the complaints about how they felt hadn't been done right, the court addressed those complaints, said, well, you know, those are, you know, maybe not ideal case working, but I don't see that this really changed the course of proceeding and demonstrated that you didn't receive reasonable efforts throughout this case. You know, and as Ms. Pierce noted, you know, I mean, you've got a parent who the case went up on appeal, and this court affirmed that she abused a child, and who's steadfast, really refusing to admit she ever did anything wrong. You don't really see that therapy is going to progress very far. Things are not. This is not a world where you're going to solve things. Where you don't take responsibility for your actions. I mean, so it's not terribly surprising to find that that the efforts were successful. I mean, and it's not surprising maybe the case was a bit frustrated with mother's lack of efforts throughout the case. And but frustration doesn't necessarily amount to a failure to assist and a failure to provide reasonable efforts. And if the court doesn't have any other further questions, that's, I think, all I had to say.
All right. Thank you, Mr.
Thank you, Your
Peterson. All right, back to you, Ms. Adams.
Thank you, Your Honors. Just a few points. First off, the GAL said that the child was strangled by mom. Let's point the court to the amended adjudication order, which I believe is on page 650-ish, one of the record. And basically, it's the mom pulled child.
Yeah, we're aware. I mean, two of us were on the panel
Right.
of the opinion that affirmed that adjudication order, so we're aware of what
We're
happened.
good on that one. Okay. The big issue, I mean, when the council's talking about, well, the court's like, well, why wasn't this stuff brought up before? Like, why isn't council consistently objecting? Thing is, this case was up on appeal for that almost the entire time that adjudication order, during almost the entire time of the reunification period. The reunification period started, I believe, in September 2019, and the adjudication order was appealed about that same time, and there wasn't an opinion from this court until August of 2020. And so things were kind of in limbo a lot of time, like what's going to happen with this adjudication order, we're not sure. And counsel frankly wasn't aware of a lot of the things that was happening behind the scenes with the caseworker until he issued grammar requests and got those notes from the case file where we see the caseworker making comments quite frequently about how she doesn't want, for example, reunification to continue. She doesn't want therapy, and it's clear once we, frankly, counsel wasn't aware of what was happening until later on in the case. And the problem with this case is that the caseworker admitted at trial that the family needed family therapy, and reunification started in September of 2019, and the caseworker admitted on the stand that she never talked with the therapists until I think it was June of 2020. So that's record 1303 and Mother's Exhibit 5. And so caseworker just sat on her haunches for months and months and months and months before even broaching the subject of whether family therapy was appropriate. And, you have to make a fair, the standard for reasonable efforts is a fair and serious effort. Sitting on your hands for 9 months is not a fair and serious effort. It's not. And then one more thing.
Can I take you back to this idea that these interim findings of reasonable efforts, particularly the stipulation, I thought you were making a point that wasn't to the clear and convincing standard.
Right.
I've been kind of mulling that over sitting here, and I've come to the conclusion that doesn't make sense to me.
Okay.
For this reason, burdens of proof are in place to get to an ultimate determination of fact. For example, in a criminal case, it's whether somebody's guilty or not guilty, and so it's going to be beyond a reasonable doubt guilty. If you stipulate to it, I'm using the correlate of a criminal case, if you plead to it, you say, I'm guilty, we don't go back in time and say, wait, did you plead beyond a reasonable doubt? No, you conceded that fact X was true. So if I have any proposition, whether the applicable standard of proof, were it to be placed in issue, is preponderance, clear and convincing, or beyond a reasonable doubt, if you stipulate to the fact, I don't see how the underlying standard of proof matters anymore. So if you stand up in court and say the state has engaged in reasonable efforts, and the court says, okay, I'm going to take your stipulation, how does, at that point, the standard of proof, had it been put in play, why does it matter?
So the difference.
Does that make sense what I'm asking?
Yeah, it totally does. And I'm totally not excited that you don't agree with my argument. I think when you're in a criminal court, as you're aware, Judge Mortensen, is that when a defendant is giving a plea,
right,
to a certain crime, the court finds beyond a reasonable doubt at that hearing that plea has shown that this guy is guilty beyond a reasonable doubt. I mean, it's made in the context of
the question then would be whether it's knowingly done. But the court will ask, are you pleading guilty because you want to get out of jail, or are you pleading guilty because you did it? He says, I did it. The court's basically saying you're acknowledging your guilt. But let's set aside that criminal thing. In any other case, when you have a fact that you're stipulating to, once you stipulate to it, why does the underlying burden of proof that would have applied had you disputed that fact matter anymore?
Because stipulations can be cabined. Stipulations are treated like any other type of contract. So, for example, in a summary judgment motion, if there's a claim with 3 elements, a party can say, for purposes of this summary judgment motion, I'm stipulating that X has been met. And if the summary judgment motion is survived, then you can go ahead and you can contest that in the trial. And that's exactly what they did here. The reasonable efforts isn't necessarily, it's an ultimate legal conclusion. It's not necessarily a fact, like I killed someone or something like that. It's more of a legal conclusion based on everything that DCFS has done. But you can cabin your stipulations. You can say, for the purposes of this hearing, I am not contesting this, because we just need to get through this hearing. And then, when you get to the trial, you can then challenge it. And so it's no different than what we see in other civil cases where there are stipulations or failures to contest certain elements of claims at a summary judgment stage, but then we bring evidence of that in, at trial, and we do contest that at trial. It's no different than what we see in other civil cases. All right, Your Honors, thank you. I ask that you reverse.
Thank you, Ms. Adams. Thank you, Ms. Pierce and Mr. Peterson. Thank you for coming down today and presenting the argument that you did. We very much appreciate it. We'll take the matter under advisement and get an opinion out to you in due course. Thank you. Court's in recess for a few minutes.